found a piece of literature, y'all. I'm gonna start off with this here. This little letters of administration petition. This is here in Georgia, of course. Y'all already know how I get down. So, and they come with their instructions as well. I just wanted to point something out. I'm gonna try to make this short. My videos be kind of long lately. Y'all know I'm usually only do like 10-minute videos, but I got so deep into this stuff, y'all. I be wanting to show what I have and, you know, give as much information as I can without putting out too much on publicly that I should be. So I'm very mindful of that, because the more I learn, the more I realize I can't say but so much on the internet. So it's a different thing if I'm talking to somebody privately, but just like being on the internet, saying every damn thing, I'm very mindful about that. Okay, concerning this right here, say this form is to be used for petition of letters of administration pursuant to OCGA. This is the code, Georgia code. I guess I'll go back and revisit that for a hot second so y'all can see what it says. Copy, it said 20, let me see. This is what it says now, but keep in mind, you got to read between the lines when y'all read these things. Get your ass on there. My laptop ain't moving slow like it was yesterday. I had to go and reset it, reboot it all over again. Say an administrator may be unanimously selected by all the heirs of a decedent of a deceased estate, unless the sole heir is the decedent's surviving spouse, and an action for divorce or separate maintenance was pending between the deceased estate and the surviving spouse at the time of the death. Okay, remove this highlight stuff. With respect to any heirs, respect to any heirs who is not sui juris, consent may be given by the guardian of the individual. So when no such unanimous selection is made, the probate court shall make the appointment that will best serve the interests of the estate, considering the following order of preferences. Bluetooth in my ear making all that noise. Somebody texting me. The surviving spouse, unless an action for divorce or separate maintenance was pending between the deceased estate and surviving spouse at the time of death. So one or more of the heirs of the estate, or the person selected by the majority majority in interest of them. And number 3, any other eligible person. Number 4, any creditor of the estate. Or number 5, the county administrator. Sounds like the judge to me. Okay? Just wanted to point that out. They have letters of administration. They issue letters of administration because of your death, your presumed death. Keep in mind, you're presumed to be deceased. Okay? Hold on a second here. Yeah, here we go. Okay. Because you're presumed to be dead. Okay? And see, this also accounts for people who actually, you know, in case you actually are dead. Letters of administration are issued to anybody who to administer your estate, whether you're actually dead or you're presumed dead. Okay, county administrator. Okay, let me see if I can point this other. Let me go back to this thing I was going to talk about. And this is an example of this form. I'm not going to go through the instructions. I'm going to show y'all the form itself. See, this is for the petition. Like, this is if you have more than one petitioner, two petitioners or whatever. Got the name, got the full name, first, middle, and last. Most likely, most of us think that, you know, most people think that, like since you're a petitioner, you think you have a first, middle, and last name, so you're gonna have first, middle, and last. Because most generally, keep in mind, this is a template. And it doesn't require you to, it says that you can use it, but it's not a requirement to use it. Matter of fact, say the use of this form is permissible, but not mandatory. In connection with the petition for appointment of successor administrator pursuant to their code, appropriate strike-throughs must be made. In addition, additional information must be and additional information must be given concerning the identity of the previous administrator, the reason for the vacancy of the office, and the date the office, became vacant. But I read that pretty much to show you that it's not mandatory that you use this template, but you can use it. But you also have to make sure that you have the let's see. Okay, you have to make sure that this, you have the, I guess the main information that's required for it to be, a valid petition. You got to have that in there, whether you use this template or not. So that's basically what I'm saying. That's what it says up there too. But anyway, you can type up your own petition, so you don't have to use, the way they have it formatted, first, middle, last. This is a template. You fix it the way you fix it. Okay. But anyway, I wanted to point out down here at the bottom when it talks about, when someone is applying for, this is the petition. Say you're trying to administer someone's estate that passed away. This is the name of the person that passed away, or the presumed dead person. Who's domicile, that's the address, remember it's intestate, that means they died without a will, okay? Without making a valid last will and testament, decedent died intestate, okay? That's the, this is the pen. But anyway, I brought this here to say right here, in under the law, it is necessary that the said estate be administered and blank. That's the person who's actually trying to, be appointed to be an administrator. Should be appointed administrator by reason of, and these are the reasons right here. Now this is not limited to this though. Keep in mind, this is a template. So if you're using a template, you're going to use, whatever reason you think this person's supposed to have, this person's supposed to have. I'm really kind of talking in code. So if you're paying attention, if you got ears to hear, you hear it. If you don't, then you probably don't need to be on this video. But anyway, being unanimously selected by the heirs, that's if you're going to check that, if you check by the heirs, being the surviving spouse, where no action for divorce or separate maintenance was pending at the time of the decedent's death, being an heir and not the surviving spouse, that's probably the kids or whatever, having been selected by majority in interest of heirs. So being an eligible person as defined by 53 6 and 1. I don't know who 53 6 and 1. I'll go back to that. But being a creditor, that's if you died and you owed somebody and somebody wanted to make a claim against your estate, or if you presumed dead and there was a creditor. Right now, you probably presumed dead. And there could be a creditor right now that has letters of administration over your estate like that. Evidence of indebtedness is attached. Let's say they got a contract attached to it, whatever. And you never, there's no rebuttal. That could be a reason why. I don't know this for sure, but this could be one reason why, one part of how somebody can actually have a lien against your name. You know what I'm saying? Because they're able to do that because there's no proof that you're alive anyway, and you never rebutted any type of claim that they may have against you. So, but that's just me thinking right there. Being the county administrator, as you saw in the state statute already. Okay. Now I wanted to so that's one of the things that gives you letters of administration, gives someone power to actually administer your estate once you're dead or presumed dead. I'm gonna go back to visit that definition so y'all can see what I'm talking about. Okay, let's see. It's a court-issued document that gives someone the authority to act as a state's administrator. Okay. I want to be the administrator of my own estate. I want to administer my own stuff. So if you have ears to hear. Okay. Let's see. Let me see. What else was I gonna say? Not this. Not that. Not that. Okay. Something else I was gonna show. That's not what I'm talking about. This little piece. It was a piece of literature I wanted to show. Here it is. Probate. Administration of an estate under absentee statute. I wanted to show this here. This was something I found. Man, I stumbled across this stuff. You can Google that same title and you can find this. but I don't know how I found it. I'm a researcher. I like looking up stuff, so I may stumble across some stuff and wasn't really looking particularly for something, but I could read a case law and I'll find something in a case law that I'm like, that's different. And then I'll even copy the code, so-and-so versus so-and-so with the code, the page or whatever that is. I'll copy the whole thing and Google that. As a matter of fact, that is how I found this. I Googled some particular case, or whatever. I found this and clicked on it and I started reading, and that's how I found what I found. This is a surprising result. Let's see, the usual modern view. I'm not going to read this whole thing. I don't think I'm going to read the whole thing. I don't think I need to, but you can read it at your leisure. I'm going to kind of let my conscience be my guide on this. The usual modern view is that there is no substantial difference between a petition and a written motion. I was just talking to somebody on the phone about this because I didn't realize this. I didn't realize I do motions just like petitions, and didn't realize that's what I was doing. But follow me on this. In the language, Gibbs versus Ewan, there is no precise boundaries between motions and petitions. The latter merely amount to motions in writings. Say in Washington, it was early recognized that the substance and not the form of a pleading determines its character and effect. I had to pause on this when I read that, because how y'all like to come to me and be like, I want to make sure I word it right. I'm like, and I get it. They want to make sure they got it formatted and all of those stuff. And I'm like, the more you study, that's how you make your paperwork effective. They know how to articulate what you're saying, and you know what you mean. They know what you're meaning based on the character and, basically what you put in the paperwork, the substance that you put in there. Recognized as the substance and not the form. It's not how you format it. It's the substance. It's what you put in your paperwork. So that's why I tell people, don't put your emotions in your paperwork. Stick to the point. Okay. The substance, not the form of a pleading, determines its character and effect, how effective it is. Okay. That's a case law. Bear versus Liebeck. Okay. The court said it is true that the portion of the application was at the hearing, at the heading termed a motion, but it contained allegations which make it in substance a petition. This is generally what I do in my motions, and I've been doing it for years and didn't realize I was doing it. I would because I have allegations in there. It's like I'm explaining something that took place, or I'm proving a point in the motion, and I'll attach an affidavit or whatever evidence I need to substantiate whatever it is I said in that motion. So it's technically a petition, even though I got in there what it says, the title. Where is it? It's in portions of application, the heading termed a motion. In the heading, I might have a motion for this, a motion to this, or whatever, motion to dismiss. I might have that in the heading. Is really the substance of what I said, how I presented this motion. It really is really a petition. I just didn't realize that's what I was doing. But but it contains allegations which make it in substance a petition. So if your motion have allegations in there, say if you got allegations, say so and so did this here, this is what they did, this is whatever, and then you have Exhibit A, and you have on the back of it, on the back of that motion, after that motion, you have exhibit, maybe a cover letter that says Exhibit A, and then they flip that cover letter and say it has your evidential certified copy of some evidence or some type of certified evidence attached to it. It's technically a petition. I didn't realize that till I read this. I'm like, damn, you're right. I didn't realize that. Okay, in reforce, whatever is the same effect. Say the court in the force case found no merit in the contention that a motion was improper procedure when a statute called for a petition, and later remarked in Harju versus Anderson, say that the pleading in the force case was titled a motion, but in substance and fact was a petition. Okay, the way it was said, the way it was put together, formatted, all that good stuff, everything that in substance, it was a petition. It was something that I wanted to say. I think I don't want to miss that statement that I found. I hope I don't know where it is in here. I'm gonna make sure. Matter of fact, let me go back to this top, the one that I skipped. This part up here, I skipped it. Decision apparently implies that filing a petition is the only effective procedure. Let's see. She contended that Superior Court jurisdiction to modify cannot be invoked by a motion and affidavit. Say Rick granted. I didn't get the whole thing. It only starts at 163, so I didn't read the beginning of this. That's why I didn't start this video reading up here. But let's see. I was trying to read between the lines with this little part that I was reading. As it provided that upon filing a properly verified petition, the Superior Court shall have full and complete jurisdiction of the cause. State ex rel. Edwards versus Superior Court. The decision apparently implies that filing a petition is the only effective procedure. But anyway, as normally what I used to tell people, do an affidavit. If you do it, you can do a motion, but I will have an affidavit or something attached to it at the end. I'm sure y'all have heard me say that in phone calls, but I didn't realize, and I've said it on videos too, but I didn't realize the way I put my motions together is really in petition form. Is in substance, is put together like a petition, and there's some type of evidence attached to it. You know what I'm saying? So I didn't realize that's what I was doing. But that's why I wanted to make this video to show you all the difference between doing a motion and doing a petition. You can put motion on your paperwork all you want to, but if it's set up with allegations and exhibits, proof, evidence attached to it or whatever, it's really a petition. You just named it a motion. But it will be accepted as one too, especially if it's verified. If it's verified, like under oath, and I do that too. I don't know why I used to do that, but I've always done that. Never realized I was doing petitions the whole damn time. Okay, where was I? I remember reading that weird word. In fact, the petition. More recently, the court said the court held that a pleading through title of motion, they say though titled a motion will be treated as a petition to ensure a hearing on the merits. So it'll be treated as a petition to ensure a hearing on the merits. That's valid. That's Valley Iron Works versus Inc. versus Independent Bakery Inc. Okay, one court has reached a result exactly contrary to that of the instant case. Bishop versus Bishop. It was held that a motion to modify the custody provision of a divorce decree satisfies a statute requiring that a petition be filed. Okay, I'm gonna read this too at the bottom. It's something I'll get to it. The instant case. Let's see. The instant case is also difficult to reconcile with McClellan versus McClellan, in which the court observed in another context that the procedural requirement of Rev Statute 995.3 Supra do not apply where the application for modification is filed in the same county in which the divorce decree was rendered. The instant case relies on the statute, even though all the litigation took place in the same county. The decision becomes more confusing when it notes that a writ of prohibition is an extraordinary remedy which should not lie unless the trial court is wholly without jurisdiction. Okay, that's State ex rel. Let's see, New York Casualty Company versus Superior Court. Say the instant case, of course, makes little impression on Washington law, but reflects an unusual strict view of procedure. I could have skipped that little part, but I read the part I really wanted to show y'all for this part, for this section. This is basically what it says about a motion versus a petition. And basically, you can actually create a motion, and it can be, in substance, like put together just like a petition. It'll be treated like a petition. So that's one point I'm gonna make probably in the title of this video. But this is the second part. Remember, I was originally talking about administration of letters of administration. Administration of an estate under a absentee statute. So a bank was appointed guardian of N's estate. We're just gonna say, we're just gonna use N as an example. In 1941, N having been adjudicated, had been adjudged incompetent. Okay, in 1942, N disappeared and was not heard from for over 7 years. Okay, P, on behalf of N's heirs, I'm gonna say that's an attorney, petitioned to the probate court for appointment of administrator of N's estate. The appointment was made, and the bank appealed it. Okay, they appealed it. So they reversed it. Then they held that where there is neither allegation nor evidence sufficient to give the probate court jurisdiction to determine that the missing man is dead. See, he was only presumed dead. He disappeared, but he wasn't proved to be dead. So they still had the right. The bank still had the right to maintain the appointment as guardianship, as appointed guardian. So that's why they had the right to appeal that case above the heirs, because the heirs only have the right once it's actually been proven that they're dead. Okay. Say his heirs are relegated to this absentee statutes for provision of their provisional distribution. Say the Washington absentee statute provides for a provisional distribution of an absentee's estate after 7 years have lapsed from the time of disappearance. The distributees, I'll just be messing these words up. Distributees must give bonds equal to twice the amount which they are to receive in order to protect the absentee should he return. Say, in due notice by publication of the distribution must be given. Final distribution and exoneration of the bonds may be had after 15 years have lapsed from the time of the absentee's disappearance. That was a particular case or whatever situation that was going on for this particular case. Something going on over here. Okay, this is concerning this Washington statute right here. Okay, probate of an estate on the presumed death alone. Say probate of an estate on the presumed death alone, which arises when a person has been absent, has not been heard from for a period of 7 years, has been held valid so long as the presumption of death remains unrebutted. Okay, as long as it remains unrebutted. I don't care, tell you all your life. After 7 years, and it's in different numbers of years depending on what state you are. Here in Georgia, I said it's 4 years. I found that in the state laws, statutes, whatever you want to call it. It's 4 years here in Georgia, but it says it will stay valid. It will continue. They'll continue to hold on to that status until it's rebutted, and that's the case law to back that up. Payne versus Home Savings Bank. However, if the absentee returns, the probate proceedings are void. Ab initio. I believe we remember what that meant. Let me see. Get back here. From being or from inception, from the being or from the inception, is used to indicate that some fact existed from the start of a relevant time period. It is often used as part of a phrase, void ab initio, meaning something such as a marriage was void from the beginning. Okay, here we go. Where was I? Yep, void ab initio, basically from the beginning. Void from the beginning, because jurisdiction of the probate court is dependent upon the fact of death. Okay. Let's see, they are dependent on the fact of death. Let's see. So not the presumption of death. That's what gives them absolute, that's what gives them, jurisdiction to do it. Once, after evidence has been proven that they're wrong, that that the presumption is rebutted, then they have to shut it down. It's void. What they're doing is void at that point. Okay, the distribution of the property in such case would be taken of the absentee's property without due process of law. Say that's Scott versus McNeil. You got all this case law in here, y'all. Y'all might want to go download this little document to your computer and read up on it, study it, learn it, get it in your system. On the other hand, distribution under absentee statute, as contrasted with the probate statutes, which provides for proper notice of distribution and requires the distributees to give security conditions that will return the property distributed to them if the absentee reappears, was held to meet the requirements of due process of law. So if your stuff was distributed out and you were presumed dead, and then they have to put up some type of bond, twice as much. Where is it? Where is it? And y'all read it? Show me where it's at. Y'all stop playing. Here it is, the bonds. Exoneration, final distribution of the bonds may be held, maybe had for 15 years having elapsed. Okay. I know I had to put a bond up in case. Just in case he returns. If he returns, he can be made whole again. Okay? What the hell is that keep flying around in here? Okay. Let's move forward. What else I want to show y'all in here? I probably won't even. I'll probably stop right here. I'm gonna stop right here because I don't want to drag this video out. But y'all want to download this video out. Download this document. It's pretty much talking about the whole thing. It's talking about the same thing about, basically administration of your estate when you're dead, when you're presumed dead, and what happens when you come back. If you was, but I want to show you the main part right here. That when you return, is keep in mind that presumption is going to continue on until that presumption will continue until you prove that you're not dead. And I'll let you do with that information what you want to do with it. But I'm gonna get on out of here. If you haven't liked and subscribed yet, please feel free to share these videos, share them on every platform that you hang out at, and bring the traffic over here so I can get the algorithm going. I'm trying to increase the algorithm and trying to keep giving y'all this information. I'm always studying, so anytime I learn something new, I'll make a video about it and make sure y'all, y'all hip to what I'm up to. Here's again, there's a title to this document. You can always go back and look it up. It's in Washington Law Review. Just look it up and you can find it. It's free. And do with it what you want to do with it. Educate yourself, empower yourself. Make sure you're up on what's going on. Stop listening to people running their mouth from trying to teach you stuff and don't want to show you where they get stuff from because they want you to call them privately so that you could pay them. Okay, if they ain't willing to give you some nuggets, sometimes give you some goddamn nuggets. Just stick to the videos, study for yourself. There's nothing wrong with paying for information if it's valid. But a lot of these people out here selling books, selling templates, selling programs, and they're not really teaching you nothing. They just want to keep you in the dark on most of what they're doing, and they don't want to tell you what they're doing. Even when you talk to them, when you have a consultation with them, they don't tell you the real deal. They just kind of keep you needing them and keep you fleecing, keep you coming back for more consultations, because they'll hold back on information. They won't tell you what they want to tell you because they want to stay in business. Okay, so be mindful about that and educate yourself, y'all. All right, keep y'all hold it down. We'll see y'all in the next video. Love y'all. M. Rose signing out.